the Family Code of the Philippines, Chapter 2, Marriage Exempt from the License Requirement, Article 27. In case either or both of the contracting parties are at the point of death, the marriage may be solemnized without necessity of a marriage license and shall remain valid even if the ailing party subsequently survives. Article 28. If the residence of either party is so located that there is no means of transportation to enable such party to appear personally before a local civil registrar, the marriage may be solemnized without the necessity of a marriage license. Article 29. In the cases provided for in the two preceding articles, the solemnizing officer shall state an affidavit executed before the local civil registrar or any other person legally authorized to administer oaths that the marriage was performed in articulo mortis or that the residence of either party, specifying the barrio or barangay, is so located that there is no means of transportation to enable such party to appear personally before the local civil registrar, and that the officer took the necessary steps to ascertain the age and relationship of the contracting parties and the absence of a legal impediment to the marriage. Article 30. The original of the affidavit required in the last preceding article, together with the legible copy of the marriage contract, shall be sent by the person solemnizing the marriage to the local civil registrar of the municipality where it was performed within the period of 30 days after the performance of the marriage. Article 31. A marriage in articulo mortis between passengers or crew members may also be solemnized by a ship captain or by an airplane pilot, not only while the ship is at sea or the plane is in flight, but also during stopovers at ports of call. Article 32. A military commander of a unit who is a commissioned officer shall likewise have authority to solemnize marriage in articulo mortis between persons within the zone of military operation, whether members of the armed forces or civilians. Article 33. Marriage among Muslims or among members of the ethnic cultural communities may be performed validly without the necessity of marriage license, provided they are solemnized in accordance with their customs, rites, or practices. Article 34. No license shall be necessary for the marriage of a man and a woman who have lived together as husband and wife for at least 5 years and without any legal impediment to marry each other. The contracting parties shall state the foregoing facts in an affidavit before any person authorized by law to administer oaths. The solemnizing officer shall also state under oath that he ascertained the qualifications of the contracting parties and found no legal impediment to the marriage. Chapter 3. Void and Voidable Marriage. Article 35. The following marriages shall be void from the very beginning. 1. Those contracted by any party below 18 years of age, even with the consent of parents or guardians. 2. Those solemnized by any person not legally authorized to perform marriage unless such marriages were contracted with either or both parties believing in good faith that the solemnizing officer had the legal authority to do so. 3. Those solemnized without a license except those covered by the preceding chapter. 4. those bigamous or polygamous marriage not falling under Article 41. 5. Those contracted through mistake of one contracting party as to the identity of the other. And 6. Those subsequent marriage that are void under Article 53. Article 36. A marriage contracted by any party who, at the time of the celebration, was psychologically incapacitated to comply with the essential marital obligation of marriage shall likewise be void, even if such incapacity becomes manifest only after its solemnization. Article 37. Marriage between the following are incestuous and void from the beginning, whether the relationship between the parties be legitimate or illegitimate. 1. Between ascendants and descendants of any degree. 2. Between brothers and sisters, whether of the full or half-blood. Article 38. The following marriages shall be void from the beginning for reason of public policy. 1. Between collateral blood relatives, whether legitimate or illegitimate, up to the fourth civil degree. 2. Between step-parents and stepchildren. 3. Between parents-in-law and children-in-law. 4. Between the adopting parent and the adopted child. 5. Between the surviving spouse of the adopting parent and the adopted child. 6. Between the surviving spouse of the adopted child and the adopter. 7. Between the adopted child and a legitimate child of the adopter. 8. Between the adopted children of the same adopter. 9. Between parties where one, with the intention to marry the other, killed that other person's spouse or his or her own spouse. Article 39. The action or defense of the declaration of absolute nullity of a marriage shall not prescribe. Article 40. The absolute nullity of a previous marriage may be invoked for purposes of remarriage on the basis solely of a final judgment declaring such previous marriage void. Article 41. The marriage contracted by any person during the subsistence of a previous marriage shall be null and void, unless before the celebration of the subsequent marriage, the prior spouse had been absent for 4 consecutive years, and the spouse present had a well-founded belief that the absent spouse was already dead. In case of disappearance, where there is a danger of death under circumstances set forth in the provision of Article 391 of the Civil Code, the absence of only 2 years shall be sufficient. For the purpose of contracting the subsequent marriage under the preceding paragraph, the spouse present must institute a summary proceeding as provided in this code for the declaration of presumptive death of the absentee without prejudice to the effect of reappearance of the absent spouse. Article 42. The subsequent marriage referred to in the preceding article shall be automatically terminated by the recording of the affidavit of reappearance of the absent spouse, unless there is a judgment annulling the previous marriage or declaring it void ab initio. A sworn statement of the fact and circumstances of the reappearance shall be recorded in the civil registry of the residence of the parties to the subsequent marriage at the instance of any interested person, with due notice to the spouse of the subsequent marriage, and without prejudice to the fact of reappearance being judicially determined in case such fact is disputed. Article 43. The termination of the subsequent marriage referred to in the preceding article shall produce the following effects. 1. The children of the subsequent marriage conceived prior to its termination shall considered legitimate, and their custody and support in case of dispute shall be decided by the court in a proper proceeding. 2. The absolute community of property or conjugal partnership, as the case may be, shall be dissolved and liquidated, but if either spouse contracted said marriage in bad faith, his or her share of the net profits of the community property or conjugal partnership property shall be forfeited in favor of the common children, or, if there are none, the children of the guilty spouse by a previous marriage, or in default of children, the innocent spouse. 3. Donation by reason of marriage shall remain valid, except that if the donee contracted the marriage in bad faith, such donations may such donations made to said donee are revoked by operation of law. 4. The innocent spouse may revoke the designation of the other spouse who acted in bad faith as beneficiary in any insurance policy, even if such designation be stipulated as irrevocable. 5. The spouse who contracted the subsequent marriage in bad faith shall be disqualified to inherit from the innocent spouse by testate or intestate succession. Article 44. If both spouses of the subsequent marriage acted in bad faith, said marriage shall be void ab initio, and all donations by reason of marriage and, and testamentary dispositions made by one in favor of the other are revoked by operation of law. Article 45. A marriage may be annulled for any of the following causes existing at the time of the marriage. 1. That the party in whose behalf it is sought to have the marriage annulled was 18 years of age or over, but below 21, and the marriage was solemnized without the consent of the parents, guardian, or person having substitute parental authority over the party in that order, unless after attaining the age of 21, such party freely cohabited with the other and both lived together as the husband and wife. 2. That either party was of unsound mind, unless such party, after coming to reason, freely cohabited with the other as husband and wife. 3. That the consent of either party was obtained by fraud, unless such party afterwards, with full knowledge of the facts constituting the fraud, freely cohabited with the other as husband and wife. 4. That the consent of either party was obtained by force, intimidation, or undue influence, unless the same having disappeared or ceased, such party thereafter freely cohabited with the other as husband and wife. 5. That either party was physically incapable of consummating the marriage with the other, and such incapacity continues and appears to be incurable. Or 6. That either party was afflicted with sexually transmissible disease found to be serious and appears to be incurable. Article 46. Any of the following circumstances shall constitute fraud referred to in number 3 of the preceding article. 1. Non-disclosure of a previous conviction by final judgment of the other party of a crime involving moral turpitude. 2. Concealment by the wife of a fact that at the time of the marriage she was pregnant by a man other than her husband. 3. Concealment of a sexually transmissible disease, regardless of its nature, existing at the time of marriage. Or 4. Concealment of drug addiction, habitual alcoholism, or homosexuality or lesbianism existing at the time of the marriage. No other misrepresentation or deceit as to character, health, rank, fortune, or chastity shall constitute such fraud as will give grounds for action for the annulment of marriage. Article 47. The action for annulment of marriage must be filed by the following persons and within the periods indicated herein. 1. For causes mentioned in number 1 of Article 45, by the party whose parent or guardian did not give his or her consent within 5 years after attaining the age of 21, or by the parent or guardian or person having legal charge of the minor at any time before such party has reached the age of 21. 2. For causes mentioned in number 2 of Article 45, by the sane spouse who had no knowledge of the other's insanity, or by any relative, guardian, or person having legal charge of the insane, at any time before the death of either party, or by the insane spouse during a lucid interval or after regaining sanity. 3. For consequences mentioned in number 3 of Article 45, by the injured party within 5 years after discovery of fraud. 4. For causes mentioned in number 4 of Article 45, by the injured party within 5 years from that time the force, intimidation, or undue influence disappeared or ceased. 5. For causes mentioned in numbers 5 and 6 of the Article 45, by the injured party within 5 years after the marriage. Article 48. In all cases of annulment or declaration of absolute nullity of marriage, the court shall order the prosecuting attorney or fiscal assigned to it to appear on behalf of the estate to take steps to prevent collusion between the parties and to take care that evidence is not fabricated or suppressed. If the cases referred to in the preceding paragraph, no judgment shall be based upon the stipulation of facts or confession of judgment. Article 49. During the pendency of the action, and in the absence of adequate provisions in a written agreement between the spouses, the court shall provide for the support of the spouses and the custody and support of their common children. The court shall give paramount consideration to the moral and material welfare of said children and their choice of the parent with whom they wish to remain as provided for in Article 9. It shall also provide for appropriate visitation rights of other parent. Article 50. The effects provided for in paragraph 2, 3, 4, and 5 of Article 43 and Article 44 shall also apply upon improper cases to marriage which are declared void ab initio or annulled by final judgment under Article 40 and 45. The final judgment in such cases shall provide for the liquidation, partition, and distribution of the properties of the spouses, the custody and support of the common children, and the delivery of their presumptive legitimes, unless such matters had been adjudicated in previous judicial proceeding. All creditors of the spouses as of the absolute community or conjugal partnership shall be notified of the proceeding for liquidation. In the partition, the conjugal dwelling and the lot on which it is situated shall be adjudicated in accordance with the provisions of Article 102 and 129. Article 51. In said partition, the value of the presumptive legitimes of all common children, computed as of the date of the final judgment of the trial court, shall be delivered in cash, property or sound securities, unless the parties by mutual agreement judicially approved had already provided for such matters. The children or their guardian or the trustee of their property may ask for the enforcement of the judgment. The delivery of the presumptive legitimes herein prescribed shall in no way prejudice the ultimate successional rights of the children accruing upon the death of either or both of the parents, but the value of the properties already received under the decree of the annulment or absolute nullity shall be considered as advances on their legitime. Article 52. The judgment of annulment or of absolute nullity of marriage, the partition and distribution of the properties of the spouses, and the delivery of the children's presumptive legitimes shall be recorded in the appropriate civil registry and registries of property. Otherwise, the same shall not affect third persons. Article 53. Either of the former spouse may marry again after complying with the requirements of the immediately preceding article. Otherwise, the subsequent marriage shall be null and void. Article 54. Children conceived or born before the judgment of annulment or absolute nullity of the marriage under Article 36 has become final and executory shall be considered legitimate. Children conceived or both or born of the subsequent marriage under Article 53 shall likewise be legitimate.